The courtroom turned silent the moment the judge asked the question no one escapes. How am I going to keep you from drinking? The defendant, already carrying 2 past OWI convictions from '96 and '02, stood there with his bond revoked, desperate to go home for Thanksgiving. He'd just pled guilty, count 2 accepted, count 1 dismissed, but that didn't guarantee freedom. The prosecutor brought up the violation, the missed tests, the tampered alcohol monitor, and when the judge pressed him, the man didn't argue. He begged, "I'll blow, I'll do whatever it takes." But the judge's face didn't soften, not even a little.
Where's she going? Oh, she came in. See, this is what happens when you get in leadership. You go in, I'm gonna do a couple cases, then I'm out.
Yeah.
Take care. Yes, and to you. Go ahead.
So, Your Honor, my client is being held on revoked bond. He is requesting for his release today. Obviously, he has pled guilty to the charge and taken responsibility for his the behavior. He, as I say at the bench, does have custody or guardianship of his daughter's 6 children. He is requesting that the court release him so he can be home with those kids during Thanksgiving. When we talked about his bond, he says he wants to teach his grandson how to fry turkey this week. He is willing to comply with any bond conditions the court may order. He's requesting a second chance. He does receive disability, and does work a couple hours a week to keep that disability at a local church in Ipsy. He wants to get out, commit to his sobriety, and take care of these grandchildren with his wife.
So anything from the people?
Your Honor, I'm recommending one of those handheld blow-in devices that I believe we call it locally SoberLink. You'll recall the defendant's violation that has him in custody. He provided some sort of explanation where he admitted to tampering with the wearable alcohol monitor. Mentioned something about the cleaning supplies at his work having an atmospheric effect on the GPS, the monitor itself. And I think that if we're going to let him out, I would not be opposed, and I'd be recommending the blow and go monitors. Nothing else.
How am I gonna keep you from drinking?
I'll blow. I'll do whatever it takes. I'll blow in it. I'll do whatever it takes. I just want to be home. I get the counseling I need.
One thing I didn't add, Your Honor, is he is going to AA once a week from 7 to 9. So that is an added support there. His priors he does have priors, but they are old. So I'd ask the court to take that into consideration as well.
And my AA is at my job every Thursday.
After pleading guilty, he was hoping the court would show mercy. His attorney painted the picture: 6 grandkids, Thanksgiving dinner, and a promise to teach his grandson how to fry a turkey. But the prosecutor reminded the court why he was in custody: tampering with the alcohol monitor, blaming cleaning chemicals, and missing tests. The judge wasn't asking routine questions anymore. He wanted a guarantee, a reason to trust him. But all the defendant could offer was desperation. "I'll blow in it, whatever it takes." It wasn't confidence. It wasn't control. It sounded like a man trying to negotiate with consequences that had finally caught up.
How old's the grandson you want to teach to fry a turkey?
He's 5, and I got 1, 2.
You're not gonna really be teaching them. They're gonna be sitting up there watching.
Well, I mean, they could be standing there, but not close to me, but not for the greasy.
Yeah,
Jump
I know,
on.
I hear you.
Yeah.
I'm gonna reset the defendant's bond back to a $10,000 personal recognizance bond. How long have you been in? I put you in on the 20th.
Yes, his last PCC.
So you've been in about 4 days,
5 days.
5.
Yes.
Yes, I think so.
Here's what I'm gonna do. I usually don't go backwards, but maybe because what I will do is I will order a sober link testing device. I'll be blown to that. That's 3 times a day.
Okay.
You understand that?
Sir.
And I need you to understand that if you miss a blow, that's as good as a bad blow. Understood?
Yes.
I'm also going to order an ETG random 1 time per week.
Okay.
So you're going to be on 2 types of testing, and we're going to be able to tell if you consumed any alcohol. Understand that?
Yes, sir. Yes, sir.
I will sentence the defendant to 5 on his bond violation, 5 days, credit 5 days for the bond violation.
He'll have to go to committee.
Understand that, sir?
Out today.
Anything else?
No, sir.
Nothing for me. Thank you, Your Honor.
Thank you.
Mr. Wilson? Don't mess it up. You hear me?
Oh,
All right. Court calls the case, People versus Tamarian Jones.
Sir, I believe Mr. Clement instructed the hall driver.
Okay. Not either the side rooms nor the hallway.
Okay. I guess we're gonna take him back. I gotta have his attorney here. I can take line now. He didn't know we were gonna call it. Right.
I'm not sure. He just stepped away a few minutes ago. Restroom? Yeah. Oh, he went to the restroom, I guess.
Oh, okay. She filled those out. She's very proud of me.
I'm very proud.
Court does call the case, People versus Timothy Lacey.
Good afternoon, Your Honor. Ashley Lundy, Feltus for the people.
Good afternoon, Your Honor. Robert Ellman, with and on behalf of Mr. Lacey, who is approaching. Mr. Lacey, please state your name for the record.
good afternoon, Your Honor. Timothy Lacey.
Good afternoon. All right, record should reflect we had a bench conference or an in-chambers conference on this case. And I'm going to adjourn this preliminary examination in this matter at the people's request.
That's correct, Your Honor. I completed the green sheet for the file reflecting that the victim on the case had been in the county today. I believe they were in Dearborn. Has been in good contact with Ann Arbor Police Department requesting the adjournment.
And just for purposes of the record, Your Honor, I know we discussed this in chambers. I would like to place my objection on the record, and I would like to address bond whenever appropriate.
Go ahead.
Thank you, Your Honor. Currently, Mr. Lacy's bond is, I believe, set at $150,000 with no 10% privilege. He is the father of 3 small children. He is a business owner. He also works part-time at Habitat for Humanity and was planning on enrolling in HVAC classes coming up at the beginning of the year here. He was taken into custody on October 15th, which by my count, if my math is correct, that's 41 days in custody. This adjournment is not at the request of the defendant and is through no fault of his own. And I would like to note that Mr. Lacy's mother is here today to support him, and that kind of goes to my bond request. I'd be requesting that he be released on house arrest to his mother's residence.
Where was he residing before?
That's before.
Here in Ann Arbor.
That's
It's an address in Ypsilanti, Your Honor, with his child's mother, or one of his children's mother.
Any response to the bond motion from the people?
Your Honor, I believe the court is familiar with Mr. Lacy and the criminal history that I put on the record before that I was
Yes.
concerned about, specifically his prior juvenile adjudication for assault with Mr. Rod while armed. I would ask that the court continue the bond as currently set. I do believe that during our chambers conference, we contemplated as fast a date as possible, being December the 8th, in recognition of him being in custody. If his custody status changes, we can readdress that if need be, but I would request the court continue it. I do think the bond is appropriately set given the circumstances of this case, as well as his criminal history.
And for the reasons as stated before, also, I do believe that the bond, at least at this juncture, is set appropriately and will decline and deny the defendant's motion to reduce bond. Having heard part of the argument, at least that counsel has put on record, let me just say this, and I think the people alluded to it. My next date would have normally been the 23rd of December. One of the reasons, as we were in back, we were going around trying to find a date much earlier that we could hear the case. And so therefore, that's why I'm going to set it for December 8th, 2025 at 1 p.m. before me. So moved up significantly from when it would have normally just been adjourned to. That was, as the people were indicated, in recognition that both defendants would be in custody absent the court's decision on the bond argument. So I will deny the motion. I'll continue to defend its bond at this time. All right.
Thank you, Your Honor.
Thank you.
Thank you.
And Your Honor, that's it for me today. I don't believe I'll be seeing you again this week, so please have a happy Thanksgiving.
I indeed, once I get to it, I'm going to have it. All right. Thank you, sir. You have a good Thanksgiving too.
Thank you.
Yes. Ready for Jones? Court recalls case People versus Jones.
Absolutely.
She thought it was her. Okay. I will get to you. Trust me.
May it please the court, Your Honor. Good afternoon. My name is Adam Clements. I'm from Perkins Law Group. I appear on behalf of the defendant. State your name, please.
Jones.
Thank you. All right. Also, on this one, people are making the request as a co-defendant of the previous defendant for an adjournment for the reasons as stated. I will adjourn preliminary examination to December 8th, 2025 at 1 p.m. That's before me, and that because Mr. Jones didn't hear it, that significantly moved up from when the date would have been had I adjourned it, because I would have adjourned it to the 23rd, but I am fitting it someplace in my docket much earlier than that.
Understood, Your Honor. We appreciate that.
All right, and
Thank
I
you, Your
had
Honor.
explained it. All right.
Yes.
Anything else, Counsel?
Of course, one moment. No, thank you.
All right, very good. His bond will continue at this time. Thank you. Thank you, counsel. Have a good Thanksgiving.
Yes, Your Honor.
Court calls case People versus Mia Caruso.
Dr. Phillips.
Call.
Assistant Public Defender Davi Lieb on behalf of Ms. Caruso.
State your name.
Mia Caruso, sir.
The first case I called up when I came to the second half of the docket.
My apologies, Your Honor.
Now she's darn near last. No, we all understand it's your fault. All right,
The court should be able to complete.
I am.
As well as in divisive rights, Your Honor.
The plea form indicates that the defendant will be pleading guilty to an added count to a false report of a misdemeanor to 93-day offense. Upon her successful plea to that charge, count 1 would be dismissed. And it's also agreed that the prosecutor will be recommending sentencing under the Homes Useful Training Act.
Yes, Your Honor.
That's the court's full understanding of the agreement.
That's mine as well.
Yes, that's a complete recitation.
May I have her sworn, please?
Raise your right hand. You solemnly swear and affirm to testify the truth, the whole truth, and nothing but the truth.
Yes.
State your name, please.
Mia Caruso.
If it is this court's understanding that you are going to be pleading guilty to the charge of false report of a misdemeanor, that itself is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, Your Honor.
Understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
February 2nd, 2025, at the location of 2680 International Drive, apartment 801A, Ypsilanti Township, Washtenaw County, State of Michigan. What'd you do that makes you think that you're guilty?
I had falsified some of the details in the reporting saying that it was stolen while it was getting warmed up for a gas station run.
Say again?
Your Honor, may I have what here?
I had
I wanted to-
falsified some of the details stating that the car was stolen while being warmed up for the gas station, and that's not like how it was stolen.
So it was your car?
A company's car,
Oh,
my possession.
it was a company car
Correct.
where you worked or formerly worked?
I was formerly working for that company.
Okay, and you had one of their cars.
Yeah.
And so where was the car when you made this report?
When the report was like initially made, I believe it was already crashed.
Okay, so let me get this right, young lady. You had a car, it was a company car, you crashed it.
Someone that I know that like technically they stole it, they crashed it, and I had reported that it was stolen while it was like waiting to be warmed up at the gas station, but in fact it was already like
Hey, hold on. So somebody you knew stole the vehicle, or at least drove it away without your permission.
correct,
They crashed it,
correct.
but not so bad that it was undrivable.
It was. I believe it was flipped upside down.
It what?
It was flipped upside down. It ended up like getting flipped in the crash.
Okay, so then at some point you called the police because of that?
Yeah, like they had told me that like, hey, accidentally crashed your vehicle. Can we like get this figured out? And I was like, okay. Let me come up there,
So, hold
figure out
on,
what's going on.
hold on. The police arrived at the crash scene, right? Or no?
I
Your Honor,
believe,
if I may, she was not present at the crash scene.
yeah, I wasn't at the crash.
Okay, so they called you or somehow got through to you and you
Yeah.
needed to call the police.
When after like I got a call from like my friend saying that they crashed my vehicle, I came up there and I had reported that like the vehicle had been stolen. It had been stolen while it was being warmed up for the gas station. When in fact,
Okay, now the gas station falls. I couldn't
Yeah.
figure out after
You're
the
like,
crash how it got to the gas station.
you're like,
So
yeah,
you told the police that the vehicle got stolen when you were warming it up at the gas station.
correct.
That was incorrect and false, right?
Yeah.
And the very fact that, well, you knew how it was stolen, but you didn't disclose that to the police.
After I got brought in for an interview, is when I disclosed like the whole
But your
story.
initial report
But yeah,
was not
correct.
that, correct? Okay. And in doing so, you were in telling them about the warming up of the car and then whatever, then you were intentionally misleading the police and that report was a false one.
Correct.
Is that correct?
Correct.
If I accept your plea, I need you to understand that if you commit misconduct between the time that I accept your plea and the time of sentencing, you commit misconduct as defined in the Michigan court rules, that any sentence evaluation or recommendation the court would no longer be bound by, and you would not be entitled to withdraw your plea. You understand that?
Correct.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None known to the defense, Your Honor.
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's?
Yes, Your
You are
Honor.
satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
January 15th at 10 a.m.
January 15th, 2026, 10 a.m. That is before Judge Washington. For a bond. Why?
Like, why did I say it?
Why all of this?
I didn't know what to do in the initial situation, to be honest. Like, it was like from 3 to like 6 a.m. I was just like tired. Didn't know what was going on. First ever like crazy thing. Yeah,
How old are you?
20.